Good afternoon, everyone, and welcome to our Roman Law Challenge presentation. We are group number 1, LLB Madrid, and this legal analysis has been made up of our group, which is myself, Viviane Paola, Alexia, and Juan Manuel.
Before we start, we just want to clarify that you, as in Antonio's friend, will be referred as Jupiter for this memorandum. In 56 BC, Aemilius had his golden statue stolen. Antonius, the alleged thief, entrusted a statue of suspicious resemblance to Jupiter via depositum. That year, Antonius went to fight under Crassus' military campaign, leaving the object under deposit for a supposed period of 5 years. 3 years later, in 53 BC, Aemilius comes to Jupiter with the claim that he might be the owner of the object. After Aemilius described the small black spot on the statue, Jupiter agrees to show the statue, and Aemilius' claim is solidified when he sees it.
So, what legal relationship binds Antonius and Jupiter? The legal relationship binding them is contractual, and it falls into the category of real contracts. It is known as depositum. Antonius stands as a depositor and Jupiter as a depository.
As a depository, Jupiter is the factual possessor of the statue. He holds corpus, but he does not hold animus, so he cannot qualify as the title of possessor. A re vindicatio can be established by specifying unique aspects of an object. Hence, a claimant cannot win a case without specifying clearly the object that is in question. Antonius has enough grounds for a re vindicatio, as he described the statue's unique black flowered shape stained with precision, sufficiently to establish a lawsuit.
Acciones in rem, or actions about a title to dominion and other real rights, fall within the category of vindicaciones. The statute is a res nec mancipi, and therefore it involves an action in rem where no attention is paid to the identity of the defendant. Aemilius' hypothetical claim would be based on the establishment of a formula petitoria, with his intentio to declare the object as his. Action will be granted because a re vindicatio can be formulated as a formula petitoria.
Must comply with a minimal standard of care, established by bona fides, also known as good faith, under contracts. Jupiter, as the depository, must resist Aemilius' claim to uphold the entrusted statue. It must be borne in mind that a conflict in the application of bona fides arises. Jupiter should give back the statue to Aemilius, given his obligation to comply with bona fides, but this can only take place if the title of ownership has been proven to be Aemilius. So two possible applications of bona fides are clash, as Jupiter must uphold bona fides to both Aemilius and Antonius.
The transfer of the statue to Aemilius should be determined by the judicial decision of legal experts in due procedure. If the object is taken away by court, this frees Jupiter from his liability by bona fides for not returning it to Antonius.
Moreover, Aemilius failed to present evidence of the original acquisition of the statue via emancipatio or traditio, which could have solidified the return of the statue. Since he couldn't present any evidence of acquisition for ownership, or he didn't want to, Jupiter does not have the legal certainty to forfeit the statue.
Therefore, this leads us to the final question. In the event of a suit whereby the claimant is Antonius, given that Jupiter had not presented a legal defense to protect the object's factual detention, would Antonius be successful? A thief could bring forward an actio depositi against a depository regarding the stolen property he had deposited. However, for this claim to be valid, Antonius would have to establish his interest in the statue in compliance with bona fides. With respect to D.5.1.64 PR, Antonius would have been unsuccessful in his claim because bona fides would have been established by the judge with reference to the interacy of the claimant. If the thief's interest in the property is dishonest, he has no claim. Because the deposited property had been acquired unlawfully, this leads many jurors to completely bar the thief from raising an actio depositi against the depository, because it is deemed that a thief could not have an honest interest in what he had stolen.
However, with respect to the first part of D.16.3.1.39, a claimant can make an isurendum in litem with the action depositi, as this law stipulates that direct action is granted against the depository, for in this case, gross negligence. This would be presented as the rationale for why the thief can be granted action. Usurandum in litem enables Antonius to make the evaluation of his own interest in the property. So essentially he could establish that he had acted according to bona fides. The thief being liable to the owner, he therefore had an interest. Conversely, the same law states that a contrary action is granted to the depository when a man knowingly deposits stolen goods and the depository is troubled. So an argument against the application of isurandum in litem is that it is incompatible with bona fides, meaning that no party should establish interest by himself.
This dilemma is resolved when we examine the requirements of isurandum in litem, which specifies that actio depositi can be granted with isurandum in litem if this is to be employed with actiones in rem. As previously mentioned, the statute is a res nec mancipi, so actiones in rem will be allowed to be undertaken and Antonius will be able to file an actio depositi.
When an actio depositi is granted, the degree of culpa is determined on the basis of the depository's failure to uphold the minimal standard of care. Jupiter could face an accusation of a three-ladder scale: levissima culpa, levis culpa, and culpa lata. Moreover, it's clear that the charge would establish culpa lata, given that this one focuses on the failure to uphold a legally imposed duty or negligence. This brings us back to D.16.3.1.39, which stipulates the possibility of a claim for gross negligence against the depository, in this case, Jupiter.
This leads us to our final recommendation. It must be noted that we had to mention the plurality of possible outcomes arising from Antonius's action in court in order for Jupiter to make an independent and informed decision. However, the conclusive recommendation that my wonderful team and I, IU jurists, have arrived at advises Jupiter to keep the statute and dispute it in court in the event of a re vindicatio being filed by Aemilius.
If the case is lost, no legal liability would be held against Jupiter with regards to the bona fides he owes Antonius. If Jupiter chose to give the statute via traditio to Aemilius outside the context of a suit, he would therefore be held accountable under bona fides. This would enable Antonius to file an actio depositi under the usurandum in litem and hence charge Jupiter with culpa lata.
I just want to thank you all for listening to our presentation, and I hope you all like it. Thank you very much.